Do you own any property in South Africa? Do you intend to acquire and own property in South Africa? This video is designed with you in mind. It is one in a series of videos which gives you a thorough grasp of the issues related to property rights in South Africa. I hope that you find it useful, but before we proceed, remember to click the likes and the subscribe buttons, to press that notification bell, and to share the video and the channel with your friends. Otherwise, contact me at iclassvirtual@gmail.com. Follow Philani Lithandane on Facebook, Philani Lithandane Ndlovu, and then Twitter at iclassvirtual. I hope you find the video useful. Let's go to the next part. We had already highlighted in one of our videos that there are many types of property rights that a person may enjoy in respect of property. Ownership is one of them, and the other rights are, of course, possession, limited rights in the properties of others, real security. We spoke about mortgages and pledges and so on. So ownership is the focus in this particular video. As we are recapping, you must understand that in order to fully understand what we mean by ownership, it must be viewed within the broad context of property rights, as I've already said, possession being one, servitudes being another, real security being another two. So we do have a video on servitudes. Don't forget to check that one out, just to get a full understanding. We do have one on possession as well as one on real security too. So those are the different videos that you'll have to check out separately and individually. Talking about ownership, we have highlighted in another video that ownership is the most comprehensive real right, where we say that it is often expressed in the maxim, that is the Latin maxim of utendi, fruendi et abutendi, where we are saying you have a right to use, to enjoy the fruits, as well as to destroy the property. So it's very important that we understand that you see, property is the most comprehensive real right. You see, there's no other right that supersedes in terms of superiority the right of an owner, because really the owner has such far-reaching powers in respect of the property. Of course, use is very, very straightforward, but of course, as we have said elsewhere, that use is regulated by the state in terms of the police powers doctrine, whilst the enjoyment of fruits is also without limitations. And of course, we know that, as I said earlier, you cannot drive your vehicle on a public road without a license for it, even though you own it. And so the right to destroy is a very controversial one. How far can you destroy? How far does the right to destroy property exist? For instance, if you own a mansion in the lofty suburb of Waterfall in Midrand, can you then one day decide, because it is your house, you can just set it on fire, destroy it there? I think again it comes now to the issue of the regulatory powers of the state. And then that's the right to destroy. But well, that's as far as that is concerned. Then in order to be the owner of property, you must acquire the property. So there are methods of property acquisition which we classify between original acquisition as well as derivative methods of property acquisition. Under the original acquisition, we have occupation and prescription, whilst the derivative methods have got to do with the purchase, because in terms of those, property must be transferred from one person to another. In other words, the person purchasing and receiving transfer of the property does so as a derivative right, or rather on the basis of a derivative right, which as he derives the power from the previous owner. So talking about this acquisition of property, that is the right of ownership, there must be a delivery if it is a derivative means of acquiring or method of acquiring property. So delivery is expressed as, in Latin they say traditio. It occurs when there are particular conditions met. Among them, the thing must be capable of ownership. That is something which is res in commercium, as we said in one of our videos. And the seller must have legal capacity to sell and to transfer and to dispose. And the seller must have the legal capacity to do so. In other words, if you are a minor, you may not dispose of property, or a prodigal, or somebody who is subject to a sequestration order, that is an insolvent. So legal capacity is very, very important when it comes to this. And then by operation of the principle that no one can transfer more rights than he owns, the nemo plus juris transfer ad alium potes quam ipse habet principle. It's a mouthful. Don't worry much about that. But we have explained the concept there in brackets by saying no one can transfer more rights than he owns. So in other words, the person facilitating a delivery must be the owner, or must have competent rights to transfer the rights, and the seller must have the intention, that is the animus, to pass on ownership to the buyer. It cannot be accidental, and the delivery must be made to the buyer or his agent, that is to a specific person, and the buyer must have legal capacity to become the owner of the thing. For instance, you cannot buy a firearm unless you have been licensed to acquire a firearm in terms of the law. So we are saying the buyer must have the legal capacity to acquire that which is being transferred to him. The example of a firearm makes it very clear here that you must have the competence to do so in terms of law. And then the buyer must accept delivery intending to acquire ownership in the thing. It cannot be accidental. For instance, if one person believes that he's leasing a property and another one believes that he's donating the property, we cannot say a delivery has taken place, because the intentions of the two do not coincide. So we have traditio, and then we have got another type of delivery which is called constructive delivery. Here we are talking about transfer of a method of transfer of property whereby ownership it doesn't follow a physical handing over of property. For instance, one person may buy a motor vehicle from another, but still retain control of the motor vehicle. Or what of a case whereby the leaser of property sells the property to the lessee, and so that now, whilst the leaser, the lessee is still in occupation, the rights change from a lease agreement to an ownership agreement. So we say there a constructive delivery has taken place. So there are different types of constructive delivery. We have a delivery by a long hand, the longer money, or a delivery by a shorthand which is brevi manu. And then we have also an example of a constitutum possessorium, and then maybe the example that I gave above, where the one receiving delivery was already in control, in physical control of the property at the time when it is delivered to them. And then there is symbolic delivery, and sometimes there's the issue of atonement. All those are examples of what one may call delivery that is classifiable between traditional and constructive delivery. So still talking about ownership as the complete power of a property through though subject to restrictions. We have facets of property that are limited in terms of public law and the rights of others, and examples of restrictive public laws such as sanitary laws, building regulations, traffic rules, and so on and so forth, as well as neighbor law. You can, for instance, not go out and make loud noise, maybe through throwing regular parties which disturb the peace of your neighbors. So neighbor law does restrict property rights to some extent. We may have to compare ownership with possession. We have highlighted above that ownership is the most, exclusive right in property, whilst possession may just mean exercising physical or control over property. So you find that ownership and possession are, of course, not the same thing. Ownership is real right that subsists even when possession is enjoyed by another person. For instance, you may lease your property to somebody else. You remain the owner. So the leaser is the owner and the lessee is the possessor. So you find that possession has two elements. It has a factual element and as well as a psychological element. What we mean by a physical element, the physical control of a thing. For instance, the person who drives a truck or a bus by the highway, freeway, exercises possession of the vehicle. Of course, we do distinguish between bona fide and mala fide possessors, lawful and unlawful possessors. But as I am saying, possession is a factual thing. It means, it refers to one who has effective control over the property, determines what direction it takes, where it can be found, who can use it, and so on. Whilst the psychological element or the intention element, what is described as the animus domini, the intention to dominate, is a very important leg too. So you notice that physical control in the absence of an intention to do so does not constitute a possession. For instance, if you are right there in your apartment or your house where you are, and then somebody sneaks in and places a machine gun there in your property, and then a few moments later he walks in with the police and they search the property and find that there is an unlicensed firearm in your property, we may not really call that a possession. It may not be said that you are exercising possession of that property because you don't have the intention, you didn't even know that it was there. So that's a very important distinction that must be drawn in respect of possession as requiring a mental element. Just maybe as a brain teaser, which of the following scenarios would represent possession? Tabo, a taxi driver who leaves the taxi car by the parking lot while he goes shopping at the mall. Is he still exercising possession of the vehicle or not? What about Susan, who holds a friend's expensive winter coat while the friend participates in a swimming competition? Right. Does the scenario here featuring Susan meet the physical or the factual control as well as the psychological element, the physical and the psychological elements of possession? What about Temba, who steals and drives the car on the freeway while the owner looks frantically for the car? Would we then say here in this scenario that there is possession? Is there, if there is possession, what kind of possession is it? Is it lawful or is it unlawful? Is it bona fide or malafide, and so on? So those are some of the key issues. For instance, in the case of Tabo, since Tabo is the one who drove the vehicle to the shopping mall and left it by the parking lot and still holds the keys, he is the lawful possessor of the taxi vehicle. But Susan, in the scenario, doesn't have the intention. He's just holding it, is holding the coat temporarily while the friend is swimming. So the physical element or factual element is there, but the psychological element is not there. So those are very important issues to remember whenever you are dealing with the key elements of possession. So we spoke earlier about delivery of property from one person to the other. There is an element called acquisition of property, how one acquires property. We have what are called original methods of acquisition. So basically there are two types of methods. There's original a method of acquisition and the derivative method of acquisition. By original methods, we mean acquisition of property without the cooperation of a previous owner, e.g. through manufacturing. And then derivative methods are based on an acquisition from a previously, handed over by a previous owner through a process of delivery that will be pursuant to a sale and a purchase agreement. Original acquisition can be illustrated in this scenario where we have Sipho, who catches a bird by its nest on a tree out there in the jungle. This is a method of original acquisition of the bird as property, since there was no one who previously owned the bird prior to its catch or acquisition by legal Sipho. Take another brain teaser. We have another method of acquisition through what is called prescription. Look at this. What if Mr. Ndlovu occupies a house owned by Mr. Sidibe for a period of 30 years, whilst Mr. Sidibe does not object to the occupation of the house by Mr. Ndlovu? Does Mr. Ndlovu acquire ownership of the house? Well, in terms of the law of prescription, yes, acquisition may follow through that uninterrupted occupation for such a lengthy period of time. So Mr. Ndlovu does acquire ownership of the house by the principle of prescription. So, as I said earlier, prescription is a form of original acquisition. The other, of course, being occupation, as in the occupation of terra nullius, land that has not been previously owned by anybody. Or if you catch a bird like legal sipo in our scenario above, or a hunter who catches game, he becomes owner of the game because nobody owned it prior to the catch. Prescription is thus a way of acquiring property as well as a way of losing property rights. So in our example, Mr. Ndlovu, who occupies Mr. Sidibe's property for 30 years, becomes an owner and gets entitled to the registration of that property in his name on the basis of the theory of adverse possession, whilst Mr. Sidibe loses rights in property through, the process of prescription. So prescription basically then means that if you occupy property for a long period of time, the statutory 30 years, without interruption, then you are entitled to its registration in your name. To create legal certainty, the law upholds the impression created by the actual owner to confer ownership to the adverse occupier. That becomes the issue, because we can't have property that runs for long periods of time without anybody claiming ownership. So if you let it without proper monitoring, and somebody occupies it for 30 years and you don't even object, then they acquire the right to own the property. So that was as far as original acquisition of property was concerned. Now we look at derivative acquisition. In what way does John acquire ownership of the bird when he buys it from Sipo? So Sipo is the boy on the left side there, and then we have our bird in the middle, and we have John coming in from the right side, and he's carrying money and he wants to buy the bird from Sipo. This is a method of acquisition which is called a derivative method, since John becomes an owner subsequent to a transfer of rights by Sipo. John derives it from Sipo, so that's a derivative ownership. So in derivative acquisition of property, you ask yourself what role delivery plays in the acquisition of property. Acquisition of property obviously is facilitated and enabled by delivery. So without delivery from the previous owner, it may be difficult to prove acquisition of property. In fact, there is no acquisition of property. So acquisition of property, that is of immovable property, it's subject to registration at the deeds office, because you see, a farm is too big to physically deliver. But if you go back to our earlier slide where we spoke about methods of delivery, you find that registration is a form of delivery also. It's not the traditional, but it is a form of delivery whereby the purchaser then acquires ownership rights on the basis of that delivery. Because of the importance of property rights, you find that there is always a need to protect ownership. There are some remedies available in law to facilitate the protection of property. That is the protection of ownership. We have reivindicatio, whereby ownership is protected through the remedies, which entitle the owner to claim his or her property from anybody who wrongfully possesses it. Take an example. Togo lends her car to Lindiwe to use for 2 months, and one day Togo gets upset, breaks into Lindiwe's garage in her absence, and drives away in the car. Is that lawful? Is that legitimate? There is a protection of maybe possession. In this particular case, the law would, Lindiwe would have recourse to the law on the basis of mandament fan spoli, or a spoliation remedy, whereby the lawful possessor is protected by the law. Since the agreement between the two had been a lease agreement, Lindiwe's protection is Lindiwe's possession is protected through that spoliation remedy. So we are actually saying that rights in law are protected to ensure safety and to ensure that those who are in lawful possession, even unlawful possession, are protected in law in order to prevent what we call self-help and chaos in society. Thank you very much for taking part in this presentation and being attentive unto the end. Maybe just as a way of recapping, we have spoken about ownership, and we have looked at the concept of ownership itself, how it relates to other concepts such as possession, such as servitudes, and yes. So you remember we try to sketch out what we mean by possession, what we mean by ownership, and what we mean by possession, the relationship between the two of them. We spoke about delivery, we spoke about methods of acquiring property rights such as ownership. Thank you very much for taking your time. Once more, remember to click the like button, to share the channel with your friends, to subscribe, to hit that notification button, and to participate in our community, YouTube community, that is the iClass virtual community. Thank you very much. Enjoy your day.